Hello, and welcome to California Gun Law. I'm your host, Don Hammond, with an update on the Duncan v. Bonta case regarding California's restrictions on standard capacity magazines. On March 20th, 2025, the Ninth Circuit upheld California's ban on magazines that hold more than 10 rounds. The California Rifle and Pistol Association filed a petition for writ of certiorari in the United States Supreme Court on August 15th. Several states and firearms rights groups have filed Amicus curiae briefs, and interestingly, the United States has not yet filed an amicus brief in Duncan, but they did file a brief in another case asking a court to strike down a standard capacity magazine ban. Let's dig into the current status and fate of California's standard capacity magazine ban. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearms laws and regulations, and there are lots of traps for the unwary. We want to help you do it right so that you won't need our criminal defense legal services. Today, I'll discuss legal updates in the Duncan v. Bonta case. This is a case by the California Rifle and Pistol Association challenging California's restriction on purchasing or possessing magazines that hold more than 10 rounds. The case was filed way back in May of 2017, and a lot has happened since then. The law at issue is California Penal Code Section 32310. The first part of this law prohibits people in California from manufacturing, importing, selling, lending, buying, etc., any firearm magazine that holds more than 10 rounds. The law goes on to prohibit possession of such magazines and to mandate that you either remove them from the state, sell them to an FFL, or surrender them to law enforcement for destruction. Fortunately, that second part has never taken effect due to the various injunctions while the Duncan case has been pending for over 8 years. This case has a long history of jumping up and down between the Federal District Court, the Ninth Circuit Court of Appeals, and the United States Supreme Court. I'll summarize, try to follow along. The Federal District Court ruled in favor of gun owners in 2019, creating what's known as Freedom Week before the Ninth Circuit stayed that decision. The appellate court then affirmed that ruling. Upon rehearing en banc, a larger panel of appeals judges overturned that decision and ruled against gun owners. The case went to the Supreme Court, and in 2022, the Supreme Court granted review, vacated the ruling, and remanded the case back for further consideration in light of its then recent opinion in New York State Rifle and Pistol Association versus Bruin. So the case went back down to the Federal District Court. In a surprise to no one, the District Court judge again ruled that the magazine restriction law was unconstitutional. Skipping the Ninth Circuit panel, the same en banc panel that heard the case before commandeered the case in a procedurally questionable move. And surprise, they again overturned the lower court ruling. The en banc panel again upheld California's magazine restrictions on March 20th, 2025. However, there is still a stay of enforcement on certain provisions of the law pending Supreme Court review. So if you lawfully own a standard capacity magazine, you can continue to possess it in California until we get a decision from the Supreme Court. On August 14th, the California Rifle and Pistol Association filed a petition for writ of certiorari in the United States Supreme Court. That's a fancy way of asking the High Court to take the case. Since then, several gun rights groups and 27 states have filed amicus briefs asking the court to take the case. An amicus brief is a friend of the court brief providing information or a position for the court's consideration. No state or organization has yet filed a brief, asking the court not to take the case, with the exception of California Attorney General Rob Bonta. On October 20th, the California Attorney General's office filed their brief in opposition, asking the Supreme Court to allow the Ninth Circuit ruling to stand. In their brief, Bonta's office argues that the Ninth Circuit ruling was correct, and that magazines are not arms for Second Amendment purposes, and that the nation's historical tradition of firearms regulation is sufficiently similar to California's magazine ban. They also argue that the Supreme Court has recently declined to hear a few other magazine cases. They were correct in doing that, and they should also decline to hear this case. They also argue that the provisions requiring Californians to get rid of their magazines is not a taking, just like how when a state outlaws drugs, it's not a taking for the state to not have to buy everybody's drugs back from them, but they can just rule that they're dangerous. Interestingly, on September 18th, the federal government filed an amicus brief in another case called Association of New Jersey Rifle and Pistol Clubs, Inc. versus Attorney General of New Jersey. In that case, the federal government filed an amicus brief in support of gun owners, encouraging the court to strike down a standard capacity magazine ban. That case is pending in the Third Circuit Court of Appeals. It would be great if the United States would file an amicus brief in Duncan, reiterating that position, asking the Supreme Court to grant certiorari and strike down California's standard capacity magazine ban. We'll see if they take that step. The next step for the Duncan case is for the Supreme Court to decide whether it wants to hear the case. The case has yet to be set for a conference. A conference is where the 9 justices of the Supreme Court discuss whether to take a case. When the justices vote whether to take the case, if 4 out of the 9 agree to take a case, then it is added to the Supreme Court docket for additional briefing and argument. If fewer than 4 justices are interested in hearing the case, then cert is denied, and the Ninth Circuit ruling will stand as the permanent final ruling in the case. The Supreme Court has recently declined to hear a number of Second Amendment cases, and standard capacity magazine cases in particular, but those have generally been in a different procedural posture. Most of those cases have come up at the preliminary injunction phase of the case rather than after a final judgment. This makes Duncan different. The case has had 2 final rulings at the federal district court level and 2 full opinions from an en banc panel of the Ninth Circuit Court of Appeals. The issues are fully fleshed out. The Supreme Court has already agreed to hear 2 key gun cases in the last few weeks. They accepted a Hawaii case regarding excluding CCW holders from all private businesses unless a sign allows firearms, and they accepted a case regarding a federal law that prohibits drug addicts from possessing firearms. There are several key issues in Duncan that might interest the court. There's a circuit split to resolve, which is a large consideration when the Supreme Court decides whether to take a case. In Duncan, the Ninth Circuit joined the Seventh Circuit in holding that magazines are not arms protected by the Second Amendment. The D.C. Circuit Court of Appeals, in a case called Hansen versus District of Columbia, held that magazines are within the definition of arms protected by the Second Amendment. Additionally, the Third Circuit, pre-Bruin, also held that a magazine, regardless of capacity, is an arm under the Second Amendment. There's also a dispute between federal appeals courts as to where common use fits as a factor in deciding whether something is an arm protected by the Second Amendment, or whether common use is part of the historical tradition inquiry. The Takings Clause issue is another interesting aspect of this case that might interest the Supreme Court. Generally, the government cannot order citizens to dispossess themselves of lawfully acquired property without compensation. If the full statute in Section 32.310 ever takes effect, it will require people to get rid of magazines that they lawfully own. So that's another interesting aspect of this case that is not present in most other Second Amendment litigation. The folks at the California Rifle and Pistol Association have done a great job of sticking with this case for over 8 years, and hopefully we're near the finish line. We'll keep you updated when the Supreme Court makes its decision as to whether they'll hear the case. In the meantime, your previously owned magazines are safe for now. Thanks for helping me reach over 20,000 subscribers on this great channel. I've updated the news section on cagum.law to keep a running update on hot topics, so check that out to stay up to date. And while you're there, pick up a coffee mug or a t-shirt to support the cause. I'm Don Hammond of California Gun Law. Stay informed, stay legal, stay safe.